In this video, we're going to take a look at first registration of title in the Land Registry. You need to understand that there are two systems of registration in Ireland in relation to property and land and so on. One is the Registry of Deeds and two is the Land Registry, which is the registration of title. The Registry of Deeds involves the existence of documents being noted. Registration gives no validity save for a judgment mortgage. It is not conclusive of ownership. Title is not guaranteed by the state, and the property is identified by parcels and maps in deeds. This is a complete contrast to the Land Registry, which is the newer system. The Land Registry sees title guaranteed by the state. The effect of the document is noted, for example, ownership. Title and folio are conclusive. The map is accurate and complete and maintained by Land Registry, accessible online, freely, openly online, and all holdings are identified by a plan number. First registration. First registration in this context means entering title to lands in the register of lands that have been unregistered up to that point. So you may have bought a property that's essentially a registry of deeds property, and your solicitor will now need to enter it, make a first registration application to Land Registry. Registration is compulsory in the state now. If registration is not carried out, then title does not vest in the party who holds under a conveyance or assignment. So you need to register your title. You need to make an application for first registration in Land Registry because registration is compulsory, it's not optional. Firstly, you have a first registration based on documentary title process. This will require a statement of title in chronological order giving a summary of the documents and events and facts on which the applicant is claiming the title to the property. This must commence with a good root of title. The statement of title will be contained in Land Registry Form 1 or Form 2, and it should give full information on any points that would be raised by a purchaser in a transaction. Your application will be under Rule 19 subsection 2 of the Land Registry or Land Registration Rules. A good root of title is at least 15 years old. So that could be a sale, a conveyance, say 15 or 20 years ago. Therefore, the title to be shown should be a period of at least 15 years, commencing with a good root of title. However, if the value of the property is less than 1 million, then there is, when the market value of the property, the subject of the application, is shown to the satisfaction of the authority not to exceed 1 million at the date of the application, the title to be shown by the applicant may commence with a conveyance or assignment on sale made not less than 12 years prior to the date of the application. That would be a good root of title on a sale under a contract limiting only the length of title to be shown. So 12 years is the period of time for which you show a good root of title. And that will be a good route insofar as it will be a conveyance or assignment for money, for value, and it will be not less than 12 years prior to the date of the application. Rule 19.3 provides, on a sale where the purchase money of the property does not exceed 1 million, the authority may register a title as absolute or qualified or good leasehold on production of a certificate by a solicitor at the expense of the applicant in Form 3, adapted as the case may require, and an application map. So this is a process or a situation where the solicitor will certify title in a form called a Form 3, and the solicitor basically certifies that he or she has checked title, has reviewed it, is satisfied with it, is certifying it, a map goes in, and that's a relatively straightforward process because it's only one form, as it were, and it doesn't involve the long chronological setting out of title from the root of title and so on, as we've seen in the other scenario there, where you're setting out in a statement of title in chronological order a summary of the documents and events and so on. That is not the situation in a Form 3. A Form 3 can be filled out by a solicitor provided the transaction on which he or she is relying is less than 2 years old. The application requires the lodging of all of the original documents of title as set out in Rule 15.1b and 16.2b of the Land Registration Rules. And that, when I say lodging of all original documents, that is to do with this process of an application based on documentary title. You're relying on these documents. Application for first registration, where the title deeds are missing, is a common problem which can be overcome. Strenuous efforts should be made, however, to investigate if any copies of documents are available from previous transactions, and an affidavit dealing with missing title deeds will be necessary. The application for first registration based on documentary title will need to be made on Land Registry Form 1, that's for a freehold title, or Land Registry Form 2 for a leasehold title. Form 1 and 2 contain the necessary paragraphs of the Affidavit of Discovery that's necessary, and a Form 16, that is the Affidavit of Discovery, is not necessary in these cases. Therefore, an application for first registration based on documentary title needs a Form 1 or a Form 2 and the documents relating to title and commencing with a good root of title. You need to note that Form 1 and Form 2 contain the necessary averments, that's the swearings, which are found in Form 16 in the Affidavit of Discovery. Therefore, a separate Form 16 is not necessary, provided the relevant averments or swearings are in Form 1 and 2. Searches must also be carried out relating to the title in the possession of the applicant. Full registry of deed searches should be lodged along with Judgment Office and Companies Office searches where appropriate. Burdens which are evident from the examination of title must be entered on the freehold folio that is opened. If appurtenant rights are to be registered, title to those rights must be shown and an appropriate map which complies with land registry requirements submitted. The application map must comply with the Land Registry mapping requirements, that is, a PRA approved map, a Property Registration Authority approved map. Title to be registered. The title which is normally applied for is absolute title. This can be given where the title is approved by the Property Registration Authority. Good leasehold title is used where the leasehold interest is approved by the Property Registration Authority, but where the lessor's title has not been established. This is the title that will be applied for in most cases of a leasehold interest. Good leasehold title. Qualified title then is title registered subject to specific limitations which are entered on the register. If an application is not successful in establishing absolute or qualified title, the PRA may register title as possessory title. The forms for first application for first registration. An application for freehold title should include your Form 1, a statement of title, a schedule of documents, an application map, all original documents and deeds, all searches, fees, and the Form 17. An application for leasehold title will involve pretty much the same forms, except you'll be using Form 2 rather than Form 1. Form 3 then we've referred to there already, an application using the Form 3 procedure if there's a recent sale in the last 2 years, for example, where the consideration does not exceed 2 or 1 million euros is acceptable. This is a modified form of first registration and it involves the solicitor vouching and certifying the title of the purchaser. There are many circumstances where the Form 3 procedure is inappropriate, including where title is based on voluntary conveyance or assignment or assent on death, where any part of the title is based on possession, where the conveyance or assignment is over 5 years old. The above list is not exhaustive. The documents to be lodged include Form 3, the original deed of conveyance or assignment within the last 2 years, a mortgage if any, copy of the lease if it's a leasehold interest, a PRA approved map, Form 17 and the relevant fees. First registration then of title based on possession. There are two elements to an application for first registration based on possession. One is possession for the required statutory period, usually 12 years, must be proved. And two, the title against which adverse possession is claimed must be identified. This application is based on possession and not to be confused with an application for registration based on adverse possession under Section 49 of the Registration of Title Act 1964. The Section 49 based application deals with adverse possession of registered land only. In other words, the land is already registered and the applicant is claiming the interest by adverse possession against the registered owner. Form 6 of the Land Registration Rules is the correct form for this application based on adverse possession, while Form 5 is the correct one for registration based on possession. In other words, a person might be in possession for many, many years, but may not have the title deeds or may not have all of the title deeds to make a good application, as it were, based on documents for absolute title. Possession of lands, to be clear, involves actual occupation of the land and or receiving the rents and profits out of the lands and generally performing acts of ownership. This involves dispossession of the owner. It is for the applicant to prove the facts on which the application is based. If an applicant can prove possession for the statutory period, but there is a difficulty proving the title against which adverse possession is claimed, the applicant can apply for possessory title from the word go. When the property has been registered for 15 years, the possessory title then can be converted on registration of a transfer for valuable consideration to absolute or good leasehold title. The statute or periods of possession are for a person 12 years, and that's to adversely possess against a person 12 years, but in relation to state property it's 30 years. Rule 17 of Land Registration Rules, application for first registration based on possession, where an application for registration of ownership of property is based on possession, or where the applicant has no documents of title in his or her possession or under his or her control in relation to such property, and the authority is satisfied on inquiry or otherwise that the applicant is in possession or in receipt of the rents and profits of the property, the application may be made in Form 5 with such modifications as the case may require. Adverse possession versus non-adverse possession. Adverse possession must be possession that is open, unconcealed and unequivocal. There is no adverse possession where acts are equivocal, for example, permissible grazing of lands. Animus possidendi is required for adverse possession and involves the intention to acquire the property and involves the necessity to exclude the true owner. Possession in every case will be determined with reference to the particular circumstances of the case. This will depend on the land itself, the natural use of the property, the course of conduct of the proprietor and other factors. The intention of the true owner is important, as a squatter cannot dispossess a true owner unless the squatter's use of the disputed land is inconsistent with the true owner's purpose for it. For example, the true owner may be happy to do nothing with the land for a number of years, but intend to use it in the future. Possession of land implies actual occupation of the land and or receiving the rents and profits out of the lands and performing acts of ownership in relation to the land that are consistent with the interest claimed. This involves dispossession of the true owner. Courts have interpreted disputes in this area liberally in favour of the dispossessed owner. Valuation office records and certificates do not prove title, but may be useful evidence to support an application. Hope you find this video useful. You will find that article there that I'm reading from. That's my blog post which I wrote. It's on my website, businessandlegal.ie. My name is Terry Gorey. I'm a solicitor in Enfield in County Meath, and the website, as I say, is businessandlegal.ie, and you'll find that article there. You'll find a link then as well to the land registration rules, but bottom line is you will need a solicitor to make applications for you in order to have a successful application for first registration with Land Registry. And remember, registration with Land Registry is compulsory, so if you buy a registry of deeds property, you must make an application for first registration with Land Registry. Hope you find this useful. If you are watching on YouTube, I'd appreciate if you gave us a thumbs up down below, and you might be interested in subscribing to this channel. And if you are listening to the podcast, the Irish Law and Small Business podcast, on iTunes or Spotify or wherever, you might be interested in leaving a review or following me, etc. Thanks a lot.